Thank you all for being here.
Thank you.
Thank you for letting us be here. Chairman Dutton, Vice Chairman Murr, members of the committee, my name is Joel Rogers. I'm the Associate Deputy Director for Policy, Legal, and Program Operations for the Office of the Attorney General Child Support Division. Thank you for the opportunity to allow us to come speak to you today about our agency. A little bit of background, the Office of the Attorney General is the Title 4D agency for the state of Texas. Title 4D refers to the section of the Social Security Act that requires all states to operate a child support program as a condition of receiving federal public assistance funds. The responsibility for administering the child support program in Texas has resided with the Office of the Attorney General since 1985. As the Title 40 agency, our office is responsible for locating absent parents, establishing paternity, establishing child medical and dental support orders, and enforcing and, when necessary, modifying those orders. Unlike most other states' programs, our agency also facilitates the establishment of conservatorship and possession and access orders, or parenting time orders, for children when we establish support obligations. The Child Support Division has a strong tradition of excellence, innovation, and service, even in the face of challenges. One such challenge is a steadily increasing demand for our services. Since 2005, our caseload has grown 67%, or by more than 613,000 cases. That growing caseload has been absorbed by our agency without any significant increase in FTEs. During that same period, our child support collections have grown from nearly $1.9 billion in 2005 to over $4.37 billion collected in the last fiscal year. Currently, we have over 1.5 million cases serving over 1.7 million children. That means approximately 1 in 4 Texas children are served by our program. Since 2007, Texas has led the nation in the highest collections annually of any state child support program, and we continue to lead in almost every quantifiable measure, including collections per FTE and cost effectiveness. Moreover, our program has saved taxpayers an estimated $1.86 billion in fiscal year 2018 by avoiding and recovering public assistance costs, including TANF, Medicaid, and food stamp payments. At the Child Support Division, our mission is to encourage responsible parenting by promoting the involvement of both parents and ensuring that children get the support they need and deserve. We're proud of our achievements because our success means success for the families that we serve. But as long as even one child goes without support, we know we still have work to do. We appreciate the opportunity to come visit with you today and look forward to working with this committee on behalf of Texas children. Thank you, and I'd be happy to answer any questions.
Thank you. Thank you for being here. Any questions, members? Well, let me ask a couple, maybe more than a couple. Let's talk about the method Texas uses to collect child support. Is that different than any of the other 50 states, and if so, how?
In terms of method, do you mean the child support guidelines?
Yes.
Yes, the child support, we've actually delivered to each member of the committee a copy of our guidelines report. I think that was delivered to your office while we were having the hearing last week. But it talks about the different methods of states use to calculate child support. The method Texas and I think about 8 other states use is the percentage of income model that essentially based on the non-custodial parents' resources available either through income or other through a job or other types of income, rental income and things like that. And then you use a percentage model of how you say 20%, if there's one child, it's 20% of the obligor's net resources. That increases if there's more than one child in the case, and it also decreases the other way if the obligor has other children to support. And so that's the model Texas uses, and we've been using that since we've had child support guidelines.
And we don't look at the obligee's resources.
We don't. There is a exception. There's a deviation from the child support guidelines allowed, but it's rarely used to look at the income of the other parent. So generally, we just look at the non-custodial parent's income.
Okay. Ms. Kalani, I think, has a question.
Why don't you look at the other parent's income?
Well, we don't look at it because the child support guidelines in Texas don't factor that in. So that's basically the reason. Other states use a different model. It's called an income shares model. That's where you factor in both of the parents' income to get the total amount that the child should receive if the household were together, and then based upon a percentage of that total amount of income, based upon the amount that is decided, you decide if one parent has 55% of the income, the other parent has 45%, then the parent who is the non-custodial parent, if that was the 55%, would pay 55% of that total amount. And the states vary because the states that use income shares model, they're not all the same. They all have variations in there. So you have to almost look at each state individually because there are deviations that aren't common through all the states.
Have you ever looked to see if doing the income shares model that would increase or lower the average child support payment in Texas?
Well, it depends. It depends on the income of the parties. We've looked at it in the past, and you can look at it. In fact, depending on the percentage of income that the custodial parent has, it could either be more or less than the Texas child support guidelines. In our caseload, because so many of our custodial parents don't have a lot of income, I would think it would tend to skew the numbers upward a little bit for the non-custodial parent.
And does the new tax changes, how does it affect child support collections in Texas?
Well, the new tax laws,
yes.
When the tax laws that went into effect last year, what it did was it created more income for the non-custodial parents, essentially, because the standard deductions went up. So it actually, when we did the calculations, I think we talked with you through the Texas Family Law Foundation, and there were some discussions with you about that. But it actually created more resources for non-custodial parents, which would have increased normal child support awards.
But you would have to do that under a modification filing when you're done.
We would have to do that through a modification, and we've determined that the change in the tax law in and of itself was not a grounds for a material substantial change of circumstances.
Yes. Okay.
Yes.
All right. And that's, I guess that's your story, and you're sticking to it.
Well, yes, sir.